Well, hello, everybody. The DUI guy is back once again for some more content for you guys. I hope that you all are having a wonderful, wonderful, wonderful Saturday evening. Today, I'm going to be hosting this by myself. Chris had other obligations. So I figured what better way to do a live stream? Something I haven't done in a very long time. I've been doing a lot of case review and arrest review and stuff like that on my channel. Today we're going to be doing something completely different. We're going to go back to the old school, old style, teaching method. So today is basically going to be like I remember if I did months and months ago, I did videos on expungement. I did videos on various aspects of the law, DUI law, non-DUI law. I mean, we covered a whole host of different areas of practice, both legal and non-legal related. As you can see, I broke out the suit today, obviously, and we are in it to win it. So, hey, Richard. Hey, Brandon, VO, and Dr. CC. Welcome to the chat. We're here just a minute and a half into the live, and you guys are already in. Much respect. I really appreciate it. So today is a very interesting topic. As you all know, I'm a trial lawyer, and I try jury trials as well as bench trials, which are a lot less frequent, but those do happen as well. And today we're going to be doing something very, very, very interesting. Something I've never done before. Something brand new for even my regular viewers. We're going to be talking about winning strategies for jury trial. Okay. And the reason, well, there are a couple of reasons I'm doing this. Number one, I really like reviewing videos with Chris, the former cop. So it's not as interesting to review them on your own anymore. If at one point he decides he doesn't want to do this anymore, obviously I'll go back to doing them myself. But unless and until that happens, I'd like to continue reviewing videos with him. That's number one. Number two, we actually just had a verdict. We had a jury trial in Elizabethtown, Kentucky. And we got that coveted 2-word not guilty verdict. So hopefully we'll maybe have some content for you all shortly about that. But, it felt good. It felt really good. Obviously, getting a not guilty verdict always feels good for both yourself and your client. And I just figured that this is something that I've never really truly talked about. Even though, I do jury trials for a living. I've done more than 24. I'm approaching like 36 trials, I think, under my belt already. Most of them victories. I figured there are certain things, obviously, that maybe I wouldn't want to share or shouldn't share or couldn't share or won't share. But there's a host of things that I can talk about because obviously I don't want to prepare prosecutors who are going to be going up against me in the future to counter like all these things. I'm not going to be shooting myself in the foot. That just seems completely ridiculous. But I am here. I want to educate some criminal defense attorneys about winning strategies for their next jury trial, and you as a pro se litigant. And we're going to go. Obviously, we're going to start with. We're going to go back in time a little bit before you actually begin your jury trial. We're going to talk about that, and then the actual jury trial itself, and maybe we'll touch upon bench trials or something like that. If I forget, remind me in the chat. Hey, Jenny. Hey, William, Jason, Ross, Liberty Blair, JJ, and Craig. Welcome, welcome, welcome. Thank you, Richard. I really appreciate it, brother. He says, congrats on the win. So that's a great question, William. When prosecutors see me in court, why do they think they can get away with proceeding with subpar cases? Because sometimes they do win. I can't, there's no ands, ifs, or buts about it. Sometimes those 50-50 cases where I think there's no way the jury can convict, sometimes they convict. There's just no escape there. Obviously, we try to win those, and usually we do, but sometimes we have several that can slip through your fingers. And you got to watch out for those. You got to watch out for those. You got to understand, and you learn, after losing one or two, you kind of realize, what can I change? How do I change it? We're going to be talking about all of this stuff today. Again, this is just experience. This is me having tried over 30 cases, both to juries and judges, to verdict or to a mistrial, to whatever. Like it ended. There was no cliffhanger or anything, and I was the first chair, meaning I led the show. I wasn't like riding shotgun, which is okay too. There's no problem with riding shotgun, but when you're riding shotgun, you're not running the full show. You may have like a witness or two that you're cross-examining. You may have you may do the opening, you may do the closing, you may do bits and pieces, but to be the star of the show, start to finish, from the moment the jury walks into the room to the moment they come back with a verdict, is very, very difficult and exhausting and tiring. And thank you, Richard, for the Starbucks coffee money. I appreciate it, brother. I'm gonna cheers to that I have my tea. And I'm gonna enjoy that. I appreciate that, brother. So thank you, Richard, for that dono. So let's start. Let's go back in time, right? You have a case. You are trying. Thank you, Jenny. You are trying to, this case is going to go to trial. What should you do? I mean, obvious practices. You want to make sure that everything that the prosecutor has in their possession on your case, you have as well. Obviously, if you don't have it, you're going to be ill prepared. And if you did not request it before trial, the judge will not give you an opportunity to review it before trial. If you did not ask it, the prosecutor doesn't really have to give it to you. That's the bottom line. If you don't ask, thou shalt not receive. So always ask, and ask for everything. Try to make your motions as comprehensive as you possibly can. Is there video? Is there body camera video? Is there jail video? Is there dash cam video? Did he have a camera on his shoulder, on his head, on his hip, on his person? Did he have any other officers with him with video? You want to make sure you have everything that they have. The citation, any supplemental reports, everything you can get your hands on, you must get your hands on, because it will be used against you in front of the jury. Make no mistake about it. So once you have all of that, once you have reviewed everything, there are certain pieces of evidence you may want to try to exclude. And that's either through a motion to suppress before trial, which sometimes judges will hold the hearing right before the jury walks in. That happens on occasion. Other judges like to hold their hearings well in advance if they want to have time to make a ruling, and so on and so forth. And sometimes a decision to exclude evidence sometimes is not evidentiary, does not require, an evidentiary hearing. You want to move right through, skedaddle right into that trial, and file a motion in limine. I don't care how to pronounce it. The spelling is Limine. Everybody pronounces it differently. It's a simple motion that you're asking the court, based on the law, to exclude certain pieces of evidence. For example, in a DUI case, the preliminary breath test, the PBT as we call it, is not admissible in court. Every defense lawyer knows it. Every prosecutor knows it. It's good to have it on paper. It's good to kind of just mention it. Oh yeah, by the way, don't talk about the PBT. Sometimes when you're dealing with a veteran prosecutor, like I did on Wednesday, I didn't even make that motion. I didn't even talk about that. Why? Because I knew that they were not going to talk about it. I knew that it was irrelevant. I knew that it had no bearing on the case, and it was not going to go one way or the other, because my guy refused the PBT anyway. So, and that does not come in. The only time it comes in is for limited purposes, and trial is not one of them. So sometimes you, hey Duke, sometimes you still want to make, especially if you're not an attorney and you're litigating your own case, absolutely make that motion, because otherwise the prosecutor always has a legitimate argument of saying, well, counsel or, opposing counsel or the pro se litigant, whoever, never made that motion. I would have reminded the cop, and I'm sorry, Your Honor, I forgot myself. I apologize. They're very crafty at their craft. They're masters of their craft, the good ones. So you want to watch out for that. You don't want to give them the opportunity to file, not to file something and then have it bite you in the butt, because you got to remember, you can't unring the bell in front of a jury. Once the bell has been rung, once, and I know some of you have called me out, like it doesn't matter that you got an objection to that. The jury has already heard it. And sometimes you say things that may be objectionable that you don't even realize. And the objection comes in, but the jury's already heard it. I mean, that's the same thing, right? If the PBT discussion already came in, you can't. Yes, they can get an admonishment from the court, and the court will say, thou shalt disregard this evidence when you go back to deliberate, but they've already heard it. I mean, it's still going to influence their decision in some way, shape, or form, even if they're told from the bench, you may not, you shall not, you cannot, you will not. Ladies and gentlemen of the jury, take this into consideration when you go back to deliberate. They still heard it, and you can't make them unhear it, other than declaring a mistrial, bringing in a whole new jury. Now, of course, in certain circumstances, some of you have seen the video that I posted on Monday of the cop getting pulverized in court. In that video, he mentioned something that was not just like couldn't be, the jury could be admonished on and the bell could be unrung. He said something that was clearly in violation of clearly established modern law as of 2021, and that's why we had to move for a mistrial. And by the way, some of you have even asked the question, it looked like you were winning. Why did you move for a mistrial? Why not just preserve that issue on appeal in case you lose? Well, the problem is if you don't object, you don't preserve the objection. You don't preserve the issue for on appeal. So you have to object. So the only way that it could have worked is if we had moved for a mistrial. The judge denied our motion for mistrial. The case continued and we lost. Then it would have been a guaranteed 100% issue on appeal. We would have had a new trial 100%. So again, the judge made the right call, and we had to make that motion. If we just kind of sat there twiddling our thumbs going, hey, we got something good here, but you don't speak out about it, it's useless. It's completely irrelevant. Courts of appeal do not reward abstinence in court. They reward active participation. So if you speak out about something, you have preserved it. If you don't speak out about it and find it later, too bad, so sad, sucker. You missed the boat. Well, so that's motions in limine. So anything you want to exclude before going to trial. I mean, sometimes you may want to exclude pieces of evidence like the PBT, like I said. Maybe you want to exclude portions of the video, for example, that maybe talks about the PBT. Again, this is just one narrow example I'm talking about because it's, again, from experience. But you may want to exclude other things, like maybe portions of the video that you think are, you can't make the, as my associate said so eloquently the other day, the liar objection from, the movie with Jim Carrey where he is an attorney, liar. Your Honor, I object to this. On what grounds? It really hurts my case. You can't object. You can't make that objection. If something really, really hurts your case, but it's an admissible piece of evidence, you're stuck with that piece of evidence. What I advocate for in those types of circumstances, when something is really, 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 really bad and it's going to come in and you have no way around it, judo law. I forget who was the local attorney here in town who actually, I don't know if he created that term or he just uses it. I know he uses it in speeches when he talks about the topic. You take the fact, because you know what you do in judo, right? When an opponent is coming at you full force and they use all this energy against you, what do you do in judo? You don't punch them in the nose, right? You use that momentum, you use that kinetic energy that is coming at you, and you redirect it, right? And you flip them on their back, or you flip them over, or you kind of do a little something, and then all that energy is all of a sudden going into the ground instead of directed at you. Same thing you want to do with the facts. You want to take this bad fact, you want to take it, and how can you spin it in a good way? How can you spin it in a way that helps you? How can you spin it in a way that makes it look good on you rather than make it look bad on you? Hey, Tracy. Hey, Craig, Donald, Will, Den, Thomas, Fred. I think I got everybody. Thank you so much. Hey, thank you for the dono, Tracy. More coffee money. I appreciate that. So yeah, you want to use the bad facts in the best way possible, in the best light possible, in any way, shape, or form that you can. And some facts are completely inescapable. They're just going to come in and they're bad, and hopefully they're not going to taint your case to the point of destruction where you're going to get that one word verdict that nobody wants. That is guilty, of course, that what we're talking about. Hey, Cleveland area. Um, so that's basically before trial. That's everything you want to do before trial. If you have a jury trial, before trial, you want to ask for the juror qualification forms ahead of time. In some cases, you want them well in advance. In our cases, for the most part, if I have them, an hour before trial or even as the trial is going on, for me personally, that's enough. It's enough for me to review. I've studied enough psychology. I understand human behavior on maybe a different level than a lot of people. So for me, just to kind of get a basic understanding of who I'm dealing with is enough for me. And again, at the end of the day, these cases are not that complicated. We're not doing big like truck railroad, any truck litigation, railroad litigation, or anything crazy like that really truly requires an in-depth understanding of each individual juror. For me, it's very cursory, and I want to know their background, where they came from, what they're doing, what they did, and once I have all of that, I can make my own determination, right? So you want to ask for them well in advance so you can do your research, find out who these people are. Are they going to be on your side? Are they going to be against you? Do they have a family of police officers, or are they, John Doe from across the street? So you wanna try and figure out who your jurors are, what kind of education they have, what their backgrounds are. Are they married? Are they working? Are they retired? What is their what is their status, marriage status? Do they have children? If you have children, maybe that you feel like that will affect the case in any way, shape, or form. You want to make sure that the jurors that you're getting are the jurors that are going to be helping you advance your cause. And it is completely okay and within the confines of the law, at least in Kentucky, and I know several other states, there's something called a preliminary strike. There's a strike for cause, and then there's a prelim strike. The strike for cause is you're striking a juror that is so completely obviously not just won't be ruling in your favor, but has clearly stated, for example, only God can judge someone. There's no way that I could ever judge anyone. Or if it's a DUI case, they'll say something like, the traumatic event that killed my mother many, many years ago, it was a DUI drunk driver. I don't think I could ever be a part of a DUI trial and unbiasedly think about the facts. And that's okay. That's a strike for cause. You move the judge, you approach the bench and you go, Your Honor, we should strike this juror. This juror does not belong on this trial. I don't want them to relive these horrific events, and I don't think they can be fair and impartial. That's the key word, fair and impartial in Kentucky. They can not be fair and impartial on this case. After listening to all the evidence, they're still going to think like DUI drivers belong, behind bars for the rest of their lives or whatever. And they're entitled to think that. There's nothing wrong with thinking that. They're just the wrong juror for this particular case. That's all it is. There's nothing bad about it. So, and they'll get stricken for cause, and that way you don't have to burn a prelim strike on them. Well, in Kentucky, in most jurisdictions, in most counties, we get a panel of 12, and from them we get to pick 6, essentially. Now, we don't pick who the 6 are. We just get 3 prelim strikes, and then the prosecution gets 3 prelim strikes. And assuming there's no crossover, we get 3, they get 3, we should be left with 6, unless both of us pick like the same one, in which case the clerk will randomly draw out a name or two if we do have some overlap. And then we're left with 6, right? And these 6 people are going to be deciding your fate. So how do you pick them? What do you ask? Well, there are several ways of going about it. I mean, there is no one proven true method. A lot of attorneys just copy each other. Eventually, you start creating your own. It becomes kind of a hybrid. When I started out, I think I copied as much as I could from other attorneys just because I didn't have any of my own. But then eventually, as you start growing as an attorney, you kind of start realizing that there's certain things you want to include. Maybe some things you want to omit. And you find your path. You find your what's it called? You find your style, right? You find your style. And I appreciate that, Craig. I have to highlight your comment. You guys are too much sometimes. I love you guys. I freaking love you. That's just I can't. Stop it. Don't stop, right? Almost got me choked up. Excuse me. So what do you want to do? You want to find the questions that are going to lead the jurors. Well, first of all, you want to make sure that everybody talks, right? You want to get every single juror that you possibly can to say at least like one sentence or a paragraph or something. Because if you are left with a juror that hasn't said a single word whatsoever, you're in trouble because that juror can be a wild card. And you don't know what that juror is thinking. You don't know what's on their mind. They might absolutely hate your guts or your client's guts if you're the attorney. And you never got to hear him speak. So make sure that you ask every single juror at least one question. Sometimes there's these one or two jurors who love to speak, and the attorneys will focus on those two and nobody else. And there's this very, very famous tactic. It's called looping that a lot of lawyers use, and I've seen it used, and I use it all the time. Looping is when you pick on a juror and you ask them a question. So how do you feel about speeding tickets? Have you ever gotten a speeding ticket? Yeah, I have. Back in 1997, I haven't been clean since. Okay, cool. Do you agree? Do you think police enforcement of speeding tickets is a good thing? Yeah, of course I do. Yeah. Mr. Jones, and you pick on the juror right next to them. How do you think? What do you feel about that? Do you agree with juror number? Some places use numbers, some places use names. I like to use names whenever I can. Some jurisdictions won't let me. I have to use their numbers, but in most places, you can use their name. Like, Mr. Jones, how do you feel about what Ms. Adams just said? Do you agree with her? Do you disagree? And sometimes you'll get a nice discussion going. That's called looping. Is when you loop the conversation between the jurors themselves. Like they're talking amongst each other and they're answering each other. Like, I actually don't agree with Ms. Adams just said. I don't agree with her. I think that speeding ticket enforcement is complete horse crap, and every citizen is entitled to travel at the speed that they desire, or whatever. And then you'd be like, okay, well, Ms. Jones in the back, do you agree with Mr. Jones? Non-related, right? I just couldn't think of a name. Miss Smith, there we go, Miss Smith. Ms. Smith, do you agree? Oh, absolutely, I disagree. I think speeding enforcement is the most glorious thing that's ever happened in the United States of America. This is how we keep our roadways safe, and blah, 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 right? That's called looping, is when you take one answer that one juror gave and you feed it to another juror nearby. Hopefully they were listening. If not, then you can, refresh them on that and all that. So, and there are several other methodologies. Again, this is not a comprehensive course on voir dire, which is jury selection. Voir dire is the Latin term for it. It's actually means voir dire, like however you want to pronounce it. Again, there's a lot of Latin terms in legalese. It's just to keep the general public out of it, basically, is all it is for. It's really not in any way, shape, or form designed for anything else. It's trying to make it seem scary and confusing so that people butt out and let attorneys sort it out. That's the way it always has been used. But essentially, it is just jury selection. That's all it is. Jury selection. That's the modern term for it. Voir dire is a French term that actually means to speak the truth. In case any aficionados out there are interested. Well, I will, Tracy, don't forget to ask that question at the very end. I'll be doing Q&A. So remind me if I forget to please re-ask that question. I'm going to be doing lecture, and then we're going to be going through some questions. Okay. I appreciate that. Save your questions for the end. Same to you, Thomas. Even though your question is completely inappropriate, I think, but I'm not gonna focus on that. I'm focusing on you guys right now. Okay. All right. So looping is one method. Now, another thing that you absolutely positively want to emphasize in your case is the presumption of innocence, any other constitutional rights, such as any Fourth Amendment rights, Fifth Amendment rights, Sixth Amendment rights that maybe have been exercised, but you don't want to ask them directly. You want to talk about the facts of the case without talking about the facts of the case. I'll give you a concrete example. So let's say you have a situation where a police officer decided to drag you out of the car and you feel he did not have justification to do so. One of the questions you can ask potential jurors is, do you feel officers have discretion in the field? Show of hand. I love doing this. just you raise your own hand and kind of give them, it's okay. It's okay. You can raise your hand, right? How many of you feel that officers have discretion in the field? Hands will start going up. Maybe some will go, what's discretion? Like, well, they can make decisions on the fly. Oh, okay. All right. Decisions on the fly. Okay. It's a conversation. Don't forget, voir dire is a conversation. And you're just going to have a conversation about their discretion. Like, so what is that? What do you think about officers having discretion? Is it a good thing? Is it a bad thing? Well, I think it's a good thing. We want officers that are going to blah 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 blah. Okay, all right. Do you feel an officer has absolute discretion? Show of hands. No, but no one's hands going up. Okay, why? And you just pick on somebody, let's say, and well, because sometimes we don't want officers to like violate the law. Aha! You finally got what you wanted, right? Because in your case, the officer you feel violated the law by dragging you out of the car. So now you're going to be telling the prospective juror, going, okay, so tell me more. What do you mean violating the law? As soon as that is said, if nobody says it, you say it. What about discretion when they violate the law? Or do they have discretion to violate the law? Like, for example, again, you may not necessarily want to talk about dragging someone out of a vehicle, but you can. You don't have to. You can. But you're not talking about the facts. You're not saying, they drug me out of the vehicle or they drug my client out of the vehicle. You're saying, do you feel that an officer has discretion to drag someone out of a vehicle? Show of hands. Who agrees? Who disagrees? Now, you don't automatically strike everyone who says, no, they don't have discretion, because your facts are specific. Your facts are more narrow than just the general. They always have a right to drag everybody out of the car at all circumstances and all, whatever. Yours is very, very narrow. So maybe you narrow the question down. Well, why do you feel they have a right to drag someone out of their vehicle? Well, depending on how they were acting. Okay, now you're getting them to narrow down. Depending on how they were acting. I see. Okay. All right. So what would be like one behavior that you feel would be justified? Well, if they were, refusing to get out of the vehicle after the officer gave them a command. Okay. All right. What would be a situation where they're completely unjustified in dragging you out of the vehicle when you're saying, okay, I'm about to get out of the vehicle, officer, and they just yank you instead? That would be an inappropriate. Okay, awesome. And you get this discussion going, and you can use looping, for example, and you want to get them talking about, the facts of your case without talking about the facts of your case. You want to get inside their heads. You want to see where they're headed, what their thoughts and feelings are going to potentially be when they hear the facts of your case, right? So Shan plays, no, this is not recorded. So I think that is going to tell you that right there. I am live right now. This is absolutely live. Good evening, Jay. Good evening, Tabby's daddy. Welcome. Yaya, what's up, you guys? All right. So that's voir dire, basically, right? And by the end of voir dire, you haven't won your case, you haven't lost your case, but hopefully you have either the 6 if you're in district court, 12 if you're in circuit, people that are at least moderately open to listening to the evidence. They're not completely biased. Like I had one the other day who said, like, I typically tend to side with law enforcement. But then a follow-up question to that is always, well, do you think you can be fair and impartial and listen to the evidence in this case? Yeah, I could. Okay, well, maybe you'll strike him with a preliminary. Maybe you can move to strike him for cause. See if the judge agrees. The judge may go, no, I think that they're good. Okay, fine, whatever. Strike him as a preliminary. Maybe you can hope that you have 3 other strikes or 3 other jurors you have to use your strikes on, and you're going to roll the dice on this one. Maybe the clerk will strike him. Maybe the Commonwealth will strike them. Maybe not the clerk will strike. I'm sorry. The clerk will draw them out if they don't get struck. So there's all sorts of these little, tactics that you can either hope for, anticipate, gamble on, or straight up just simply use. So once you have your jury, this is where the show really begins. Because up until this point, and we always say this in jury selection, this is the only time we're going to get a chance to talk with you. The rest of the trial, you're sitting there, you're wallpaper, you're listening to the evidence, right? And we begin, right? Opening statements. Now, different states are different. Thank you very much, James Charles. I appreciate it. And yes, I do car accident cases as well, Jenny. Thank you for that, Red Rex. You started your solo criminal defense practice in Dallas. Hell yeah, bro. Good for you. Congratulations. Hello, Alexander. Congrats, man. Let me know if I can be of any help, by the way. If you got any questions or whatever, this is my 9th year, I think, as a solo. Well, not solo anymore, but since I started my practice, we're now a medium-sized firm, I guess. We're not small firm anymore, but we're medium-sized firm now. Anyway, hey Rod. So so opening statements. Opening statements. Now, the biggest mistakes I see in opening statements that irritate the shit out of me, and I think probably jurors, is when you start saying, well, I think the evidence will show. I believe the evidence will show. We believe the evidence will show. The evidence will show that. The evidence will show this. Shut up. Nobody cares. This filler language is just useless. It's empty. It's meaningless. Start out with something simple. Let me tell you a story. Oh, you're going to be making up a story? No, you idiot. The jury understands. You're telling a story of your client. You're telling your own story. Let me tell you a story. Jurors love stories. There are books written about storytelling. Tell them the story. The prosecutor just got up there. Depending on the state, the state goes first, the defense goes first. I don't know. It doesn't really matter at the end of the day. Just use your jurisdiction's rules. In Kentucky, prosecution goes first, defense goes second. Prosecutor just got up there, told his story, told the truth of what he believes the evidence will show, hopefully without saying it. Or though, let him screw up. That's his job. If he wants to screw up, let him screw up, or her. When you get up there, or your lawyer gets up there, he or she can start laying out the facts. And even if there's going to be a lot of repeat, know that you're telling the story from your perspective or your client's perspective. Just say it. There are some schools that advocate for teaching how to do opening statement from the perspective of you probably wouldn't be able to do it. Well, you shouldn't do it. Not be able to. You're absolutely able to. But you shouldn't use this if you're litigating your own case pro se. But if you're an attorney, I'll give you an example. It's 9:00 at night. I am driving from the bar over on 5th and Market. God, what is that bar called? I forget. I think it's called Hooligans. I'm driving from Hooligans. And I'm inside my own head, and I get distracted by the radio. I hate this song. Why is this song playing? Let me change that real quick. Oh my God! Oh, whoa! I almost hit that car. Holy sh! Whoo! Okay, all right. Pay attention to the road, idiot. Pay attention to the road. God, I'm such an idiot sometimes. Oh no! Oh no! Oh, come on! Is that? Oh, there's a cop behind me. Okay. All right. Got to deal with this now. I just want to get home. Why am I dealing? Okay. All right. He probably saw me over there when I was fiddling with the radio. God, that's annoying. Now you're telling, this is called a first person narrative. When you're telling the story of your story, your client's story from the first person perspective. Now, obviously, there's this whole question of, is it objectionable? Is it not? I mean, I don't think there really is an objection there. You're telling a story from your client's perspective. Public Defender's Office, I think actually here in Kentucky, advocates for that specific methodology in opening statements. I know some defense attorneys across the country whom I've met have done it before. I have not personally, so I can't really advocate, does it work, does it not work? I'm sure it does. It works for them. And again, it also depends on the case, do you want to use it in all your cases? Maybe, maybe not. I don't use them in any of my cases. I haven't tried it yet. I don't know. It's not my style. So what I do is sometimes I do an opening. Sometimes I do a very short opening. Sometimes I do a very long opening. Sometimes I do a storytelling opening. Sometimes I do just a brief, this is what I expect you're going to hear. So there are many, many different ways. There are many, many different ways of going about it. Your goal is, as my associate actually so eloquently put, is you're making a promise. You're making a promise in opening. You're making a promise that this is what you're going to hear and see as this case commences. And the jury's going to hold you to that promise. And if you deliver, you earn a little bit of credibility. If you don't deliver, you're going to lose credibility. So pay attention. Pay attention to your your opening, because they're going to hold you to the things that you say. And if you don't deliver, it's going to bite you in the ass come closing and when they go back to deliberate. So that's opening in a nutshell, right? You're telling the story of the case. And then what happens? 99.999% of the time, you're going to have the prosecution or the plaintiff go first, right? They put on their what's called case in chief. And they put on their witnesses, and they do something called direct examination. Direct examination is the who, what, where, when, why, and how questions. You cannot lead. You know, a lot of people I noticed on my comments, and I just want to smack my head and go, oh my God, I know you're not a lawyer and I'm just going to ignore you, but you do understand that leading is allowed on cross-examination, right? That's the whole purpose of. I've gotten objections, when I try to like give statement facts to police officers. Like, Your Honor, this was not in the form of a question. I don't have to ask questions. The cop is my puppet and I'm the puppeteer. Okay? I feed them information, or I feed the jury information, and the puppet is there to say yes, or is there to say no, or to qualify my statement if I said something wrong. So obviously, you don't want to be lying there. You don't want to be making up stuff, because you will get called out on it, and you will look really, 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 really bad. But the witness that you are leading on cross examination, I know I skipped around a little bit, but we'll get back to it. When this is your parrot, simply to quack yes, yes, no, no, yes, yes, no, 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 yes, yes, no, yes. That's it. That's all. If you do your cross perfectly, you should have only yes, no, yes, no, yes, no in the record from the witness. Now, of course, no trial ever goes perfectly. You're always going to have, like, sometimes you want them to say, like, so why did you do that? Like, why did you do this? I don't know. Like, and they give you an answer. Well, that's not a yes, no, and that's okay. But some people veer off completely the beaten path. You never want to ask a question from an adversarial witness. That means a witness that is against you, not on your side, like a police officer, if you're the defense, and ask them a question that you have no idea what the answer is to. Obviously, big, big no-no. This is why, remember at the very beginning I talked about, you want to make sure that your discovery is complete. You have all the evidence. You have reviewed all the videos. You know exactly what's going to happen. You have no surprises of, oh, by the way, we would like to play this video, Your Honor. Oh, I was never given to me in evidence. Your Honor, he never asked for this particular, he never asked for videos. It would never be like this particular, but Your Honor has never asked for videos, period. Well, objection overruled. Play the video, counselor. And you're sitting there going, oh my God, what are they about to see? I have no idea what's going on right now. You never want to be in that position, especially in the middle of trial. Trial is war. War is trial. Remember that. There is no middle ground. There's no peace offering. Very, very rarely is there it's trench warfare, straight up. So and direct examination, again, I kind of skipped over it just because it's the simplest thing. You just ask who, what, where, when, why, and how questions, and you let the witness sing like a canary. You can lead them very briefly, like, so this all happened at 6 p.m., like obvious questions. You can lead them on. No one's going to be, objection, Your Honor, leading the witness. You're going to look like a moron if you object to that. Okay, don't object. Make your objections important. Object where it's important, where it truly you should be objecting to, not minutia like that, So, this happened at 6 p.m., Officer Smith. Yes. And this happened at the intersection of Gloss and Franklin. Yes. And the defendant was driving a Jeep Wrangler, 2008 Jeep Wrangler. Yes. Those are all like obvious questions that you already know the answer to, and everybody in the room except the jury knows the answer to. So even though it's a leading question, it's okay on direct examination. But you can't be like, and then the car pulled over. Yes. And then you asked them out of the car. Yeah, Your Honor, objection, leading the witness. I'm sorry, Your Honor. And then what happened? Did oh, I got him out of the car. Okay. What happened after that? Well, they started running, whatever it is. Your Honor, objection. It hurts my case. Not a real objection. Don't use it. You're going to look like a moron. Okay. Leave it for the professionals in the movies like Jim Carrey. All right. So, after everybody puts on their witnesses, right? So you get a chance after the prosecution puts on their usually police officers or investigators or detectives or doctors or experts or whoever that they have to present their case. You have a chance to cross-examine every single witness, right? You have a chance to get up there and be like, okay, so let's see here a minute. Well, you talked about this and this and this and that. Well, can you please clarify? Because I'm a little unclear about this point right over here that is missing a lot of stuff that you didn't talk about. Okay. That is how you start nailing these people on points that they don't want to talk about. They only want to show the case in their most positive light. Nobody wants to talk about their case in the most negative light, right? And that's your job. That's your job to make sure that the negative light gets highlighted. Oh, you never talked about this, did you? I don't recall. Okay, all right. You don't recall. That's fine. Well, what about this? Yeah, that did happen. Okay, so okay, all right. And then you didn't see this piece of evidence, and you didn't see that, and you didn't see this, and you didn't see that. No, I didn't. I didn't. And you would have written it down, and you just nail them in. You want to box them in. You want to put them in a little box, and you want to put a nice little ribbon on it, and you want to deliver that to the jury. If you can do that in a case, you have done a masterful job at the end of the day, because the jury's going to take this box and go, thank you. I don't even want to open it. The ribbon is so pretty. I'm just going to take this into the jury deliberation room, and I'm gonna include that in my deliberations, because I think that definitely hurts the prosecution's case. So thank you for the gift, counselor, and I'm going to use this. So when they go, when you finish with all of your directing crosses. And by the way, don't forget to move for a directed verdict. Directed verdict is simply a fancy term, and it's very difficult to win these. I've only seen, I think, one in my entire career. Two. No, I've seen two. I've seen two. I've only seen two in my entire career, as far as I can remember, from my own personal experience. I mean, it's sometimes it's more. Maybe there's more out there, but a directed verdict is basically when you're asking the court to take the case away from the jury and let the court enter a directed verdict for the party that's moving for it, usually the defense. And what you're asking for is, in legalese, basically, in Kentucky, is you're saying that the prosecution have not met, and this is the key language, their prima facie case, meeting the elements required to prove the offense alleged. That's it. I know there's a lot to unpack there, and we could go for another hour discussion as to what all that means. But essentially, you're saying the prosecution has not already in evidence. This is after they close their case, before you put on your witnesses, if any. There is so little in the record. For example, one of the elements is missing. They've never established that the client was driving. For example, if driving is one of the elements, operating comes in many different forms. Maybe it's not necessarily driving. Operator was asleep in the vehicle. Well, that maybe still operating, depending on the jurisdiction. In Kentucky, if you've seen my videos, you know that sleeping in the car is not always operating. Usually, it's not. So some states it is. If you have your keys, you're in the car, boom, they got you. It's a DUI, end of story, no questions asked. I think that's a very shitty way of going about it, because I don't think it's right. But every state is different. So if they have not met their prima facie, they have not provided enough evidence for a prima facie case for the elements of the crime that is being alleged, then the judge should take the case away from the jury, enter a directed verdict. It's basically a glorified not guilty, and everybody goes home. Like I said, it rarely ever happens. The prosecution has to have a really, 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 really bad case and not even realize it. And it's a waste of everyone's time, even more so. And usually these motions, like I said, do not get granted. And then you move on to the next phase, which is the case in chief for the defense. Now the defense puts on all their witnesses. Once again, now you get a chance to who, what, where, when, why, how. And I am not a cat, Pipe. That's exactly right. I am not a cat. Good evening, sir. Meow. Where'd that come from? Anyway, you get a chance to put on your witnesses, right? The defense gets to put on their witnesses. Now you get a chance to be the who, what, where, when, why, how person. And then the prosecution gets to grill your witnesses and they get to ask leading questions. Okay, so you said at direct examination that you are going to, blah, 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 blah. Can you please tell me, did you do this, and that? I didn't. Okay, all right. Now the jury's going, oh, new pieces of evidence are coming in. You didn't ask that, counselor. Why is the prosecution doing this job for you? You want to make sure your ground is covered. You want to make sure that everything that you are doing is covered during your direct. You do not want to leave gaps. So if there's a bad fact, and you know about it, and you know the prosecutor is going to be asking about it, make damn sure that you ask it in your direct examination when you are putting the witness on, because it's going to come out anyway and you're going to look horrible if the first person to talk about it is going to be the other side. By the way, I just want to bring your attention to something that is really something that the other side, I guess, just doesn't really want to talk about. And I have to bring it out just because, and they're going to make you look so bad. The jury's going to be like, wow, you're a real scumbag. Did you really think you're going to get away with it? Even though maybe you're just like, I don't know what to do with it. It's a bad fact for me. It's going to come. Ask it anyway. Like, you refused the field sobriety test. That's a bad fact. Like, what are you hiding, right? What are you hiding? He's not hiding anything. He refused him because he didn't trust the scumbag, whatever, POS cop. Because he didn't, the cop was acting completely unprofessionally. So he said, I'm not doing your field sobriety test. Okay, fantastic. But you have an answer. If you just leave it hanging and the prosecution gets up there and asks, well, you refused the field sobriety test. Isn't that correct? Yes. And maybe they'll cut them off and not give them a chance to qualify the answer. If they're not a strong witness, you're going to have witnesses that are not very strong. And they'll just cave into whatever the prosecution says. Not every witness will be like, wait. There's more. I'd like to qualify my answer, Your Honor. And, you're going to have those witnesses. Some witnesses will just be like, yep, yes, no. So know your witness too. Make sure. Hey, Verified. Thank you for the dono. What is my rate for a trial case? It varies from case to case. I don't really do hourly rates. I do flat fee for cases. Mike, I don't do videos like this often. I used to do videos like this often. Now I kind of gravitated towards more doing some other stuff, but we may be coming back to this. I mean, I'm no stranger. This is an educational channel, so we're doing an educational piece today because I felt like it. I won a jury trial 2 days ago, and I'm on cloud 9 still. So I'm entitled to share whatever I want to share, right? You guys love listening to me, apparently. So here's to a good time. Cheers. So yeah. After everybody puts on their evidence, obviously, of course, don't forget to move for, if you did put on witnesses, always make sure to renew your motion for a directed verdict. And again, 99.999% of the time, it's going to get denied. And if it does get denied, you move on to the final phase of the trial, and that's closing argument. Now, one key little piece. Opening statements and closing arguments are both not evidence, right? And some people like to get up there and say, well, everything I'm saying, everything the prosecution just said, everything I'm saying is not evidence. And I'm like, why? Why? Yeah, you're calling out the elephant in the room, but this is the one elephant you want to keep in the room and nobody talk about. It doesn't matter. You're basically telling the jury to, like, everything I'm saying to you right now, feel free to completely ignore, tune out, and just like, we'll look at the clock until we're ready to go deliberate. That is the dumbest thing that you can possibly do. Don't do it. Just start talking. I know it sounds weird, but you've seen comedians, they get out on stage. Sometimes they even, call themselves out on it because they're like, it's so weird. I just come out here and all of a sudden, like, you ever look at the sky and realize how blue the sky is? Like, it's a weird thing to start just randomly talking about to a group of strangers you never met before, some schmuck on a stage, right? But they all do it. You walk out, and you may start with, "How's everybody doing tonight?" You ever been to Walmart and there's this long line and you're like, "Man, I don't want to be in this line right now." And they launch into their bit, their piece, their joke, whatever, their limerick. And just go for it. Just launch into it. Don't People will listen, especially if you're telling it well. Eliminate your eliminate as many of those as you can. If you have a chance, I just did it myself. See, you can't escape it. I mean, but there's a difference between doing them 100 times over and then doing them once or twice or 5 times. Big difference, right? So you want to eliminate your fillers and practice in front of a mirror. Practice your closing, practice your opening. If you do it 2, 3, 4, 5, 10 times, depending on how ambitious you are about winning your case, all of a sudden you're gonna like, oh, wait a minute, I can tell them, like, you're gonna have like these ideas. My best ideas come in the shower. I kid you not. All my jury trials, as they get closer and closer, I take a shower and I go, I just got my opening. I know exactly what I'm gonna do. Or, I just got my closing. Or, oh my God, I completely forgot I need to ask this of the police officer in cross-examination. I completely forgot. Like, you're going to have these. So you want to start preparing well in advance, right? And I know we're talking about this last, but this is actually the one thing. This is the one thing that you want to start with. You want to start preparing your case with a closing argument. I know it sounds weird, but trust me on this. You want to start by writing the words "not guilty" and then working back from there. What are the facts that are going to help me get there? Okay. What is the facts that are not going to help me get there, but I can judo law and make them my facts? Okay. And work backwards. And then from your closing, you're going to create your cross-examinations, and your opening will come last. Voir dire is kind of its own beast. You can leave voir dire to the dead last. But your opening will be last. And that's not uncommon. Now, after you practice, if you're an attorney, after you practice these for a while, maybe you'll write your opening first, or maybe you'll just wing opening completely. I mean, I've done that before. You're like, I know these facts, and I don't like to use notes whenever I can. I like talking directly to people. I think you create a better connection. You look more believable. You look more persuasive. You look more honest. You look more everything. When you're standing behind a podium, and there's like this piece of paper in front of you, and you're just like doing this the entire, there's a disconnect, and you lose believability. You lose a lot. You lose way more than you actually gain. But, in some cases, it's impossible. The cases I'm talking about, we usually try them in one day, just a few hours. Some cases go in litigation for weeks, days, weeks, sometimes months. You can't memorize a month-long trial unless you have a photographic memory. You're not going to be able to memorize everything in a month-long trial. It's completely impossible. So there are going to be situations where there's going to be a complete disconnect, and there's nothing you can do about it. But in short cases, it's better to have that, like a speeding ticket case, sometimes will last 30 minutes, start to finish, including openings, cross-examination, direct examination, and closings. It may even go shorter than that in front of a jury, So it all depends on the case. My DUI cases last anywhere from like 5 to 10 hours, depending on which county, how many witnesses, and so on and so forth. If we have a lunch break, and etc. So, and that's really the bottom line. So in closing, you have one job, is to summarize in the light most favorable to you the evidence that they have just heard. And hopefully there's going to be a lot of mirroring between your opening and your closing. Okay. So there's going to be a lot of overlap in what you said. And if there's, especially if they're directly overlapping along with everything that, because here's the magical thing, by the way. This is the most magical thing about trials. When you go in, you have no idea what's going to happen. You have absolutely no idea at the end of the day of what is going to happen when you walk into that courtroom. And when you go in front of them at the end, at closing, you have these little nuggets that you did not anticipate that anybody is going to say or do or whatever that happened, and you can use them to your advantage. Yeah, by the way, this is your time to speak about them. This is your time to shine. This is your time to tell them your truth, right? Finally, for the last time before you sit down. Now, sometimes, like I said, the judges will admonish the jury, what you've just heard is not evidence. They've just given the jury instructions. I kind of skipped over that too, but that's another piece. Obviously, the jury instructions is most judges require a copy of your jury instructions either a few days or a few weeks or maybe even a month before trial. So make sure you're meeting all your deadlines. The jury instructions, are basically the instructions to the jury as to how to decide the case based on the law. And some states they have standard. For instance, here we have Cooper's. Most judges will either use Cooper's instructions, or sometimes they will honor, defense's objections to instructions, or use the defense's instructions in their entirety, or in a piece, or 0%. I've had them all. I've seen them all. I've had where my jury instructions were used absolutely 0% of, and I've had cases where 100% of my jury instructions were used, and he just looked at the prosecutor going, "You can basically throw yours away," because they were a new prosecutor, I think, and I was the veteran in the courtroom. So you never know. You never know what's going to happen. So always come prepared, because if you don't speak, the answer is always no. You're never going to get to hear the potential. Don't. By the way, don't worry about objections. Don't worry. Like, if you're an attorney, I'm speaking directly to you now. Don't worry about objections. Okay. Too many people are like, well, can I say that? Like, isn't that objectionable? Isn't that going to hurt me? Well, if it hurts you, obviously don't bring it up, but hurt me in front of the judge. Like, what if the judge grants the objection? So what? So what? If it's a favorable fact and you think it's not objectionable, if you have a legitimate ground to argue that it should come in and you should talk about it, absolutely talk about it. Everything is admissible unless objected to. And some of you attorneys maybe have heard that phrase. Everything can come in unless if somebody says, "Wait a minute, I don't think this is allowed." Now obviously you don't want to start talking about things that are clearly objectionable, like jury nullification. Oh God, that's a huge one. I know Chad is probably going to explode on this little point right here. You can't talk about jury nullification, and you really can't. In a trial in a court in the United States of America, you can't talk about it. It's going to be grounds for a mistrial, because you're basically asking the jurors point blank, please ignore the law, ignore the facts, just give me that not guilty because that's the right thing to do. And maybe it is, and maybe they will, but you can't ask for it like that directly. You can lead them down that path as you're doing the trial, but you can't shove it in their faces, because you will be objected to and there will be an immediate mistrial. You can't tell them to violate the law. That's going to be an obvious objection. You can't misstate the facts in closing. There's going to be an obvious objection. So anything obviously objectionable, that facts that were not introduced into evidence, you can't talk about those in closing. So obviously those are off limits, but everything in between, like a theory of the case, I believe that the cop is a lying POS and he destroyed the video in this case. I can't prove it, but that's what I think happened. There's no objection there. This is the theory of the defense's case. You're entitled to do that. You're entitled to say that. And the jury will then be like, after we listen to all the evidence, do we believe that has any credence or credibility? Or we don't believe you. This is stupid. Of course he didn't have video from everything that we've seen and heard. Or they're going to go, that is a valid point. I do see where you're coming from. I'm going to take this into consideration when we go back and talk about it. So that's basically what the bottom line is when it comes to closing arguments. And then when the other side goes up to do their closing argument, do not tune out, especially if you're defense and you go first in these jurisdictions like ours, and then the prosecutor goes last. Don't under any circumstances go to sleep and be like, all right, I did my job. I'm good. I'm tired. We've been here for a whole day. It's like 7:00 in the evening. I'm done. Let him just do his closing and then we can move on. No, Listen intently. First of all, you're doing two things. Number one, you're showing the jury that you still care. Just because you're done with your show, you still care about the case and what's going to happen. Number two, you're also showing, well, first of all, maybe they're going to say something extremely objectionable, like one of those things we just talked about. If you don't call them out and the jury hears it and there's no objection, the judge is not going to stop them unless it's so egregious that the judge intervenes, which has happened. It's very, very rare, but it's one of those things that if you don't pay attention to it, you're probably screwed. So pay attention. Pay attention to what they're saying. Make sure that everything they're saying is within the confines of the law. And if it's not, and that means, by the way, for all of those of you pro se litigants, that means grabbing one of those sheets of paper that has, every listed objection on them. And they're out there. They're on the internet. Some judges have them. List of popular objections. Objection relevance. How is this relevant to the litigation, Your Honor? I don't understand. Objection hearsay. The witness that they're talking about is not here. Objection. There's all sorts of. I'm not going to go through the list, but find the most common ones and use them. Use the objection leading. Your Honor, the prosecution is leading their witness. They're not allowed to do that. That's going to make them look like an asshole. It's going to make them look really, really bad. And as long as your objections are proper and you don't object too much, I think you lose credibility when you object too much, because jurors don't understand what objection means. They just hear the evidence. And when they hear objection, their first thought in their minds, let me try that again. The first thought in their mind is, what are they hiding? What are they hiding? Why don't we get to hear that? Especially if it started with so you did not have any video in this case, did you, officer? Objection. And then you go to the bench and be like, okay, Your Honor, we're going to sort this out. All the jury has heard up until that point is there's no video. Why? What are they hiding? Why did they object there? Why did the defense object? Why did the prosecution object? What's going on here? So you definitely want to watch out for those. Don't object just for the sake of objecting. You're going to look like a moron, and the jury will dislike you. Object when absolutely necessary, when it truly hurts your case and you have a reasonable grounds to object. So that's closing. And after closing, after both sides close, the jury goes back, takes the jury instructions with them, and they get to deliberate and decide the case based on the facts. And hopefully when they come out, they either, if it's a civil case, they render a decision based on who gets paid and how much. And if there's a question of liability, hopefully they rule in your favor. And of course, if it's a criminal trial, then hopefully they give you that 2-word verdict of not guilty, which is the coveted verdict, of course. So, Rod, thank you for that. That is the time to submit the case law to the jury as well. Usually, if the judge has already done that, thank you for reminding me. I mean, that's basically, you're tying in, I kind of alluded to it, but I don't think I ever completed the thought. So thank you for that, Rod. You're taking all the facts, right? I told you about that you had an opening that came through cross and direct examination. You're tying them all in closing to the law, and you're showing that the law, let's say if you're the prosecutor, you want to argue that we've met our burden of beyond a reasonable doubt if it's a criminal case, and the facts show that the individual committed the offense alleged. That's it. And as the defense, you're doing the exact opposite. You've heard all the evidence, you've heard all the facts. Now here's the law, and the elements and the facts do not agree with each other. You have a disconnect. An element has not been met. There's not enough evidence to rise to the level of the offense alleged. Now, if an element has not been met, let's say, hopefully you've already won on the directed verdict motion. But if you haven't, and the judge still decided to overrule you, because sometimes judges get it wrong, it's okay. Judges are humans. They make mistakes. And if they made a mistake, you'll have an appealable issue if you lose, or if you win, you won anyway, whatever. It's okay. So, can a lawyer cite? All right, let's move on to Q&A. I know people are itching. This is one of those topics that everybody has a billion questions. So let's open it up to questions. Let's do questions. And Thomas McNulty, you have did you perform at the Improv? Which Improv did you perform at, Thomas McNulty? That's awesome. I've always wanted to perform at the Improv back when I did stand up, but I never got the opportunity. I had to resort to more local clubs, but that's awesome. I've been to the Improv a few times here in Louisville. Can a lawyer cite? Here's his question. All right, so fire away. Questions. This is Q&A. Can a lawyer cite an action or outcome in a case in a TV show like The Closer? No. That's an easy answer. No, you cannot. Because it's not established case law in your jurisdiction unless it has been entered into a published case by a court. It has to come from the court, the legislature, and so on and so forth. Law Talk with Mike. Is he in here? Oh, whoa. What's up, Law Talk with Mike? What's up, brother? He says this is fancy for a Saturday night. I know. No, the topic is, I saw you live earlier, man. Good on you. Your channel is exploding, by the way. Shout out to Law Talk with Mike right down here. And there we go. Law Talk with Mike. Go to his channel, follow him. Coolest guy in the world, man. I did a live with him one time. He also does a lot of review, and I think he interviews people on his channel too. Super cool guy, super awesome. Love you, Mike. Thanks for coming on on a Saturday night and joining us. So yeah, can you only if it's quoted in a case can you use it? Thank you, Craig. I really appreciate that, sir. Mike says, my viewers are lucky if I put a shirt on. I love that. I absolutely love that. All right. I don't know what this question is. Let's see. Donald Campbell and Rosemary Campbell. All right. So we got 2 viewers in 1 stone. Larry, have you ever defended a cop in a DUI case? For example, can a citizen report have an objective witness such as video camera? How does a citizen report a DUI cop? Okay, there's like 3 questions here. So number 1, have I ever defended a police officer in a DUI case? The answer is yes. Yes, I have. And we currently have 1 or 2. For example, can a citizen report, this is question number 2, can a citizen report or have an objective witness such as video camera? Yeah, of course. If you record it on a cell phone, it's just as objective as any other video. How does a citizen report a DUI cop? Call 911, I guess. I mean, I'm not really sure. Hey, Liberty Cause. Yeah, you are very late to the party. Very, very late, but it's okay. Welcome to the channel, brother. It's hard to... Okay, let's see. Judges make mistakes. I don't think you had a stupid question, Thomas McNulty. It's I don't know. I get questions all the time, so you're welcome. Are police reports hearsay? Yes, they are. You know, some of you who may be familiar, who have seen my videos. Thank you, Tracy, for another $5 dono. I appreciate it. She says, Mike and Larry, my 2 favorite guys. And look at that. We're both in one room. Both in one room. Hey, Mike, do you want me to like add? I don't know if you're in a position to be added. This is totally sua sponte I'm doing, by the way. Do you want to join me on this live real quick? I can send you a link. Just let me know in the chat. I'll be more. I don't know if you're dressed for success right now, or if you're sitting in your underwear on the couch watching this. So no harm, no foul either way, brother. Just let me know. Are police reports hearsay? Absolutely they are. If you've seen my videos, you know that a lot of times police officers will have that piece of paper and they'll be holding it, you know, reading from their citation directly into evidence. They can't do that. They can't do that. The piece of paper is not evidence. It is hearsay. We have no proof who wrote it, when they wrote it. The fact that the person reading it wrote it. Citation is not evidence. It is hearsay. The officer, any witness, must testify from memory. Now, if there's any notes that may refresh their memory, if they're like testifying and they're like, wait a minute, I don't remember, was it a 1995 Jeep Wrangler or 1998 Jeep Wrangler? I don't remember, counselor. Would reviewing the citation officer refresh your recollection on this case if I show it to you? Yeah, absolutely. I'm going to take a look at it. They look at it. Okay, yeah, it was 98. It was a 1998 Jeep Wrangler. I'm sorry. Okay, all right, cool. You know, they got it. Let's see. Mike says, sure. All right, sweet deal. Let me add you. Let me add you to the stream real quick, Mike. I'm sending you the link here. Give me one moment. Here we go. All right, sir, go ahead and check your email. No, that's not it. Hold on. Link to the stream. All right, it's going to be titled Link to the Stream. And here we go. All right, we're waiting on Mike here. In the meantime, let's go ahead and continue asking more or answering more questions. Jeffrey Murray, thank you for the $5 super sticker. I appreciate it, brother. More coffee, sweet. Can cops be sued for lying on their reports? Maybe, maybe not. Depends on the case. Have I ever defended someone knowing they was wrong? I don't know what that means. I don't understand that question. Have I ever defended someone knowing they was wrong? They was wrong about what? They were wrong or just was wrong? They shouldn't have existed? I don't understand. I don't understand the question. Why would a prosecutor ask for discovery from you? Well, if they believe that there is something that you have, a piece of evidence in your possession that they don't have, that they want. Here we go. There he is.
Hello, hello, hello.
The man in the flesh himself. How you doing, brother?
Good. I was being a good boy tonight, and I was actually just being lazy because I'd done a bunch of work, and I saw your thing, and I'm like, I'll go over there. It'll be fun.
Hell yeah, dude. That's awesome.
I was so impressed because seriously, this is where I didn't, change or whatever. But I'm like, oh, he's all suited up. He's got a tie. He's looking good.
Don't even worry about it, man. Sometimes, like when I do these educational ones, I like to wear. I forgot. I was going to start with if you want to win your jury trials, make sure you wear a pink tie. And then I was just going to be like, all right, Larry Forman signing off. Have a good Saturday, everybody. I forgot to do that in the beginning, but then it's one of those stupid jokes,
I've actually got a great one that I want to do with you. It's a DUI in Washington that was sent to me. It gets a little edgy, but whatever. We can deal with that later. But that one's kind of serious. It's not really funny. I just really wanted your perspective. If we do it, we should do it on your channel.
100%, dude. Yeah. Shoot me an email. We'll do it. I'm down.
Okay.
But yeah, I'm just I don't know. Have you done a lot of litigation, Mike? Do you do that in your practice?
But not that type of stuff. But it's it's the same sort of thing. Yeah. I was just doing the Kim Blandino trial. I don't know if you saw any of that. But that was a criminal case, and it's just exactly like a civil case. The law is a little different, but dealing with judges and juries is the same thing.
It absolutely is. At the end of the day, you're trying to convince either a group of strangers or one person on the bench of the facts that they're pointing in your favor, either guilt or not guilt. Tabby's daddy is our sovereign citizen add-on. He's very cool. He's very quiet. Never quiet. I'm just kidding. I love his input because he doesn't argue. He's super chill, but he always throws in his little tidbits, and I just absolutely love that because he adds a fresh perspective to my channel. And he'll throw questions like this, like, do they teach common law in law school? Did you study common law in law school?
Well, they teach what common law means in law school, and yeah, I get a lot of sovereign citizens on my side, obviously, too. So I'm versed in these sorts of inquiries. Common law does not mean what you think it means. Sovereign citizen community generally. I don't know this person, but yeah, common law is the law based on decisions as opposed to statutory law. And by the way, the decisions are usually interpreting statutes as well. So it's all just in one big mixed up blender of stuff that we call law. That's my explanation for a Saturday night.
And you're absolutely right, Mike. And when we read like decisions in law school, because this is how you learn, how a particular law is applied. Like if you're studying, let's say, property, you're in property class, you're reading a decision about, I don't know, division of property or an easement or something like that. I mean, that is common law. You're reading a piece of common law. So asking the question, do they teach common law in law school, is almost kind of oxymoronic. You know, it's like, do they teach law in law school?
Right.
The answer is yes, but is there like a separate, this is the common law class? No, that's again, it's oxymoronic.
Well,
It's kind of like,
yeah, sure.
doesn't really
Like,
work.
for instance, I do personal injury, which is primarily torts. Torts are common law. So if you're looking at something, you'll look at the restatement of torts second or something like that to see something, because it specifically is not a statute. It's the body of law that developed over time. However, it's just loaded with statutes and things and provisions that get in there, and then it's all mixed. There's no grand distinction between those two things.
Dr. CC asks, do I ever ask jurors if they're members of MAD, Mothers Against Drunk Driving? Do I personally ask that question? No, but I come close to asking similar questions to just kind of get a feel. And listen, if someone is a member of MAD and they're like an active advocate against drunk driving, but I have I think a great case that even a MAD, advocate would be like, I don't think they deserve to be convicted of this. There's not enough here. I would keep them on the jury. There's no reason to strike someone just because of a group that they belong to that maybe does not side with your expectations. There's a big difference there.
Yeah, that's interesting. And it's not like you're trying to defend people with these cases. It's not like you're pro-drunk driving.
Right, of course. Like, who in the right mind would be like, go drunk drivers?
Yeah,
like,
right.
I support more drunk drivers on the road. Like, come on. Everybody knows. I do every year around New Year's. Those of you who know me, I do that. I buy rides for people on Uber.
Oh, that's cool.
Yeah, I literally post, like, if you're stuck somewhere and you can't get home and you can't afford an Uber, text me. I'll buy you an Uber to avoid a DUI.
Right.
So, like, I'm literally paying you to not have business. Like, who in their right mind would do something like that? Someone who does not support drunk driving, maybe.
It's funny. I actually thought of you. I went to St. Croix, and I went to a buddy of mine lives there, and I went to St. Croix recently, and I was there for a week. But and this came up, and I didn't go out, so it sort of turned into a spa vacation. I'm on top of a hill. It's really beautiful, but you're driving on the left side of the road. Okay, and
Sounds scary.
And this is my first time in St. Croix, and I'm like, nope, I'm not going to go out, because if I go out, I'll have a couple, and I'm not going to drive back on an unfamiliar roads on the left side of the road with alcohol in me. Period. End of statement. And I would have done it with Uber, but they don't have Uber on the island.
That's really unfortunate.
So my answer to that little conundrum is, don't go out. The end. That's how you solve that riddle. It's very simple.
Go out and don't drink, right?
Right. Or go out and don't drink.
Yeah, that's it.
Those are your two options. Pick one.
Exactly. Are individuals that are jurors able to inform other jurors of jury nullification during deliberations? Absolutely. If they're an informed juror that knows what that means and what it is, why not? Let's see. I'm looking for more questions. I couldn't stop laughing at the solo cup cop. Oh, the solo. I know the one you're talking about. Okay. I'm sorry. I thought this was something I did today.
That's actually why I'm here. Is one time I in the middle of the afternoon, I hopped onto one of your streams, and it was like mellow. You're just doing a quick live kind of thing. And that's when somebody started asking you a detailed question, and you're like, "Dude, I'm doing a stream," and then you go full on into your like your European accent voice. And I'm sitting there's like 3 o'clock. There's like nobody on the stream. It's like me. I'm like just giggling away. I'm like, this is lost. It's too bad. It's a good moment.
Oh, here we go. Dean Morgan, definitely not a prosecutor in hiding. If you want into acting, you should apply for vampire type characters. I love that. Any more questions, you guys? Any questions for Mike? I got him here. He joined us.
You know,
I'm gonna make you guys pick on him.
I didn't realize it was kind of fun. I see some of my people in here, and I just didn't know that. I haven't been over here for a while because I've been crazy, but that's really cool to see. So hi, people.
Mike Mendoza asks if you're a lawyer too. Yes, he is.
Why do you doubt?
It's because you don't have a tie, man. It's the tie is what seals the deal. Anybody can wear a blazer, man. It's the tie.
I've got an ascot.
Don't take it personally.
I've got a fez here. Let me jazz this up for you. You need a fez on the stream.
Oh,
nothing
dude. Okay,
nothing makes things work better.
I have to leave now. I'm sorry. I can't.
Nothing adds to the dignity of a stream like a fez.
That's what's up. I dig it, man. I love it. Are either of you in need of an experienced, not inexperienced, an experienced paralegal? Not at this time, Andrew, but Mike may. I don't know.
Not at the moment, but yeah.
One day.
Yeah. As soon as, and we're getting there, as soon as the world reopens,
yeah, for sure.
There's a backlog of cases. I mean, we're kind of getting through stuff. I'm sure it's the same. Well, it's not the same with you. I see you. You're still trying stuff.
Yeah. I mean, I had a trial on Wednesday. That was when I got my latest not guilty.
Congratulations.
Thanks,
like,
brother.
we're getting it out, but it's like slower. You know what I mean?
I mean, ours. So I was supposed to have like 5 trials by now. I had one on the 16th of February, and then I was supposed to have one like one at the end of February, one at the beginning of March, this Wednesday, and then like next week, and then the week after. Like I was supposed to have like 5 or 6 jury trials basically within the span of like 5 weeks. But some of them have been moved, some of them have been canceled, some of them have been whatever. So my next one looks like is going to go not this Wednesday, but the next Wednesday. So it's nice. It's like 3 trials in 5 weeks instead of 6 trials in 5. This week I was supposed to have 2 trials, man. It would have been a disaster.
Yeah, I had this. I don't know if you know her. I had this conversation with Natalie Lawyer Chick just the other day.
I need to
and
reach
it's
out
funny
to her,
because she does criminal defense.
Yeah,
and she had the same experience. I'm like, yeah. All of a sudden they're starting to go out, so I'm getting assigned. But the case, and I don't blame her. On our end, everything's settling. And she said, I'm getting really generous offers too. And I know why, because they're ancient files that no one wants to like go back and revisit. And people, it's just much more amenable to just coming to an agreement and moving along.
Sometimes,
not all of them, but there's a big element of that, you know?
Oh yeah, definitely. I have one that I was absolutely expecting that exact result. And prosecutor and I had a conversation. The case is 3 years and like 2 days old as of today. And obviously pandemic had a lot to do with it, but I could have sworn when he emailed me, I was like, he wants to settle this, no question. And he's like, yeah, I'll give you a DUI offer. I'm like, no, man, this thing has been set for trial for like 2 years. We're ready to go forward. And he's like, okay, let's go forward then.
I'm dying to look at this clip with you. This guy got a DUI. This is out in Washington State. Got a DUI in like 2019, and in the meantime, he's got an alcohol problem, right? And he's just got every violation under the sun in between, and they're going at it in court. But they can't get this thing out to trial, and he's just picking up more DUI. All the stuff.
Yeah.
You know all the stuff. And but it's fascinating, and the defense attorney is tenacious. I mean, these are bad facts, and he's just getting after the judge. I'm like, woo.
Which jurisdiction? You said Washington. Who's the lawyer?
Washington State.
Yeah. Who's the lawyer? Do you know?
I don't know.
Okay, we'll review it. We'll review it together. I'm dying now to see it. Do you guys ever hang with judges on Long Island? Lawyers seem very familiar with the judges. It depends on the lawyer. I mean, there's nothing in the rule book that says you can't hang out with the neutral arbiter of a court. I mean, obviously, we can't talk about cases because that would be something called ex parte communications, which you can't do without the other party being present. But there's nothing stopping you from being friends with judges.
That always cracks me up when you're like trying a case or whatever, or you're just over at the courthouse. So you're seeing like a judge that you see all the time. You talk to them about their kids. They talk to you just because professionally you know each other. No big deal. Nothing shady going on. They'll get in the elevator and there'll be like 3 other people, and you're just like, You don't even look at each other, like, because you don't want that appearance to other people. You know,
Impropriety, yeah. Because the public doesn't understand. That's why
right?
questions like that get asked by Thomas McNulty. He's firing away. Here's another one. When new laws come out, like unlawful surveillance, how are you lawyers receiving updates? What is the Okay, all right. Never mind.
What's unlawful surveillance? You know.
I don't know. Where is the USB cable inserted? I think he's just joking.
Okay.
He's a comedian. You see, he's got the little improv.
Yeah, that's pretty cool.
I asked him. He never answered like which improv he performed at. That's pretty cool.
I don't know. I saw your YouTube improv and it was damn good. I didn't know that you'd done comedy before.
I did. Yeah, way back
when.
when.
I mean, it makes sense now because I was watching. I'm just like enjoying myself on this stream in the middle of the day. But now you say that, I'm like, okay, now it makes sense.
I wasn't. My career did not like go any further than maybe 6 or 7 performances in my lifetime.
Right.
But yeah, I performed and.
But even that, you weren't even doing a bit. You were just like annoyed in exactly the way I would be. I could relate too much. That was it. You're just like, oh yeah, I'll stop my stream and answer your very specific question.
That you have the issue in your state. It's like, how do I get this done? Literally, give me free legal advice right now. Stop everything. Yeah. Don't you just love those? California has 12, I'm guessing, jurors. What about the state of Kentucky? We have 6 for district, 12 for circuit. District is misdemeanors, circuit is felonies. So for felony cases, you get more people. And Kentucky is, I don't know, you didn't ask that, but it's unanimous. I think there used to be like 3 states that did not require unanimity, or two states that did not require unanimity in criminal cases. And they were Florida and Oregon. But I think that was when I started practicing. I think since then, both of them have already overruled their prior decisions. And I think 100% of the states in the United States of America, as of today, require unanimous verdicts. You can't have, like, a civil case is a totally different story. Because in civil cases, you don't have, somebody going to jail potentially at the end of the trial. But when it comes to money, sometimes it's 9-3 is enough to get, that's considered, it's not unanimous, but it's enough to get the verdict pushed through. But in criminal cases, I believe everybody is on board with unanimity. You got to have 100%. Everybody agrees.
Yeah, that makes sense. We sometimes we have 6, but they want to do it by agreement. If there's no agreement, then it's 12. I'm like, what's the point? If you're going to agree to make it easier and have 6 jurors, and so why don't you just do a bench and be done with it?
Right. Exactly.
Which is literally like 10% of the work. You can attest to this.
As a blind dude, I'm curious if you ever ran across lawyers who are blind. Yeah. We had a prosecutor here in town who was blind, and she was a fierce litigator. Fierce. There's actually a story written about her not that long ago, right before the pandemic, in the paper, telling her story. And one of the coolest things, this is awesome, by the way. When she was young, I think she was either in grade school or high school. I can't remember. She had a teacher, really nasty teacher, who said, "You will never amount to anything. Like, you're blind. Forget about it. Blah blah blah," and very nasty. And she proved her wrong. She was like, "You know what? Screw you, bitch. I'm going to law school." And she graduated and she got her license to practice law, and she became a fierce prosecutor and a fierce litigator. So she proved her wrong.
That's usually one of the best motivators right there.
Let's see. Okay, so people are asking about Thomas Binger, and this is the second time I got this question. I think it's the same person. How many prosecutors have I run into like a Thomas? Who's Thomas Binger? I'm sorry, I'm not.
Thomas Binger, I believe, is the prosecutor in the Rittenhouse case.
Okay,
is my guess. I'm not even sure of that, but tell me in the chat if I'm right. I think he's. I don't know. And he was pretty loose with what he was doing. I was shocked.
Yeah, I mean, I've seen prosecutors of all shapes and colors.
Yeah.
So that's my answer.
It's hard to generalize. Yeah, it really is. They're just like anyone else.
Yeah.
He was on the edge more so than other people. in terms of
Like in a
candor?
bad way?
Yes.
I like
From
those
what I
prosecutors
saw, I mean, I'm not.
because they're easier to destroy.
Yeah.
Don't be afraid to call out prosecutors, by the way, in like your closing arguments, if it's merited, only if it's merited. Never attack another human being unless it's merited. If you feel that it's merited, there's nothing stopping you.
It's absolutely one of their weakest points because the prosecution, they have the power of the state behind them, and they have so much, and people instinctively know this. But if they're sleazy, if they're doing something wrong, it's worse. You've got the power of the state. You can call in troopers. You can call in this. You can call the lab. You can do this. And if you're going to be nasty, you can really do damage. And juries instinctively know that. So they literally do tend to be pretty clean for this reason, because if they can't lose their credibility. I hate to say it, but like a defense attorney would have more leeway. Hey, you got to deal with this stuff. You can have a little more. You can be a little more flowery, have a little more personality, and a jury's going to let it go. You can be a little more Better Call Saul on the defense side. But if a prosecutor cannot get away with that, that's just human nature.
Totally agree. Ginny asks if that she was introduced to my channel by Lackluster, who's another great channel, by the way. I swear to God, if we're gonna have like a trifecta here, if Lackluster joins us, this will be like epic. Do you
I don't know
support
Lackluster. What's going on at Lackluster's channel?
I don't know personally. I had him on. I interviewed him during the pandemic, like 6 months ago. I want to say
Mm-hmm.
he recently moved at the time, and he was like buying a tractor. I think he's doing really well. The last I checked with him, and I think he already crossed. Did he cross 300,000 views or subscribers yet?
My God, how do you do it? You guys are taking over the world. I do a video like every day. I'm just pounding away. Although I can't complain.
Way faster. He's way faster than anybody I've ever seen. Let's see.
Maybe you can tell me the secret. Although, like I said, I can't complain.
No, that's not it. Where is he? I don't know. Somebody can look it up and tell me. I don't know. Do I support cop watchers and auditors? Yes, I do. Do I have cops seeking revenge after I make them look like an idiot in court? No, I don't make them look like an idiot. They make themselves look like an idiot. Trying to find some good questions here. Oh, okay. Here's a good one. That's a great question, Stone. How does one find a good trial lawyer? First of all, Google, obviously. If they have lawyers who don't try cases, you can usually immediately tell by looking at their website if there are no trial results. Then obviously they don't try cases. Bottom line, lawyers who try cases try to showcase it because we're few and far in between. So if you're looking, and the other bottom line is if you suspect that maybe they do, maybe they don't, ask them. I mean, I would be hard pressed to find a lawyer who doesn't try cases, who's trying to land business so badly he's willing to lie about the fact that he tries cases. Or she. That would be extremely like crossing so many lines. Just ask, do you try cases? When was the last? But don't ask how many cases do you win. That is a bad question to ask because first of all, what is a win? Sometimes you get a guilty verdict, but you beat the offer. That's 100% win.
Yep.
Sometimes you get a hung jury and then you get a deal later. That's a win. Sometimes you get a mistrial and you get a amendment offer after that. That's a win. So. But obviously, don't like judge a lawyer by the amount of not guilties that they have received. It's very, very difficult. Like the legal realm is just so hybrid-esque in that sense. But you definitely want to find out how many cases they've tried. If they've been in practice 25 years and they've tried 3 cases, maybe that's not the best lawyer for you if you want to go to trial. If they've been in practice 5 years and they've done 20 trials, that's definitely a litigator, So, and they're going to be more expensive. Just be ready for that. They're going to be way more expensive because there's a common misconception. And Mike, I please let the viewers know if you've had this experience. A client calls you and says, listen, I want to take my case to trial, but I'm scared my deal, there's a deal on the table and I'm afraid it's going to get worse if we push litigation. Have you had that happen? What do you tell these people? What happens to, what's your answer?
It is hard. I get this question too. It's so hard to tell them because they don't know the factors. You and I can sniff it out even if it's not my practice area. I can tell who's doing what like in 30 seconds. I may have to talk to them for a minute.
Sure.
But yeah, then I know. It's a little different for me because if well, I'm doing civil. So if an insurance company's made you an offer and you're not represented, that offer sucks. And 99 times out of 100, it's a bad offer, and they're hoping that you don't get represented because you're trying to increase the value of the case. But these people, that's what's so hard. Your average person does not know the factors, and if you ask an attorney, a lot of attorneys don't know because if they're doing like real estate closings or something, they're saying who's good at DUI. They don't know. They don't know.
Basically, who's going to get a better offer, Mike? The lawyer that litigates or the lawyer that does not litigate?
Oh, absolutely.
The lawyer that litigates 100% of the time.
If you're willing
Criminal
to
and
try
civil.
the case, it increases your chances. But you're right. In my area, it's contingency, so it isn't really so much that it costs you more, but they're harder to get. And in your area, it's a billing thing, so yeah.
Well,
but does the result matter to you? Do you want a DUI hanging over you? Do you want to lose your privilege to drive? Do you want to spend time? Do you want to lose your liberty? Is it because this guy's charging a few $1,000s more than this guy? I don't know. I mean, you got to figure that out.
I realized that I asked the question in a bad way, so let me rephrase it. Let's say you have a person coming to you who was just in an accident, right?
Mm-hmm.
And they say the insurance company called me and they offered me X amount of dollars to settle, right? And you already answered it. I'm just looking for clarification for our viewers. They offered X amount of dollars. Now, if I hire a lawyer, is my offer going to get X minus or X plus?
Yeah. I'm not interested. I'm not interested in taking it depends on your lawyer. I mean, you can get really sleazy guys too, but I'm not interested in I have enough business that if I don't even want your case if I'm not going to improve your scenario. And there are no guaranteed results, but if I look at it and think, I can't do better. The more common thing is they draw an offer, they're with another attorney, and then they're upset with them. And they come to me and they say, and they say, okay, the insurance company offered $20,000. I look at it and think it's probably worth about $20,000. They're like, I don't care. I want to do it. I can boot the other attorney, and then they have what's called quantum merit, and then I can have a fight with them. I don't want any part of it. I look at it and say, you better go back to them because that's about right. So I'll give a fair evaluation. But generally, you can't do it. But generally, if you're going to an ethical person, they won't take your case if they don't think there's a good chance they can improve your position. Right. I mean, you can always improve someone's position. Always. They could have videotape of the entire event. They can have videotape of the guy drinking with a breathalyzer attached to him while he's doing it. Then get behind the wheel. It's still harder for the state to prove it with you on the other side than that guy alone. Every time. Because they're thinking this is a great case, but what if he messes up our chain of custody on that videotape or on that sample or blows out our foundation on that videotape, and I can't get the truth. We know those things. They know that the state knows that you know those things. They know that the defendant doesn't know those things.
And see, some people in the criminal world, people will come to me and they'll be like, look, I want to fight this case, but I'm afraid that the more we fight, the worse of a maybe resolution offer, if the prosecution is going to be inclined to resolve this case, maybe it's going to get worse. Maybe they're going to go from, you made me work a 6 months on this case, counselor. I'm going to give you, I'm going to give your client 6 days in jail now instead of 3 days in jail, which was my initial offer. Right. A lot of times they have that concern. And I tell them, look, if you have a reputation for litigating cases, and especially fighting the ones that should be fought, you will never have a prosecutor who is going to make your cases worse because they know that you're a litigator. They're never going to make your offers, worse. But if you do not litigate cases and you suddenly decide to take this one and fight it. And I've seen it. I have seen it
Mhm.
before my very eyes, how these scare tactics work. They're few and far in between, but I have seen them. When the prosecutor goes, "Oh yeah, you want to go ahead and fight me on this? Well, I'm gonna make your offer worse if you step out of line on this, Husky." You
Mhm.
know, and the lawyers, put their tail between their legs and go, "Yeah, I can't do this. I'm sorry." And it's sad, it's scary, it's a reality. But that's where you got to find the bulldogs, find the
Mhm.
lions, find the hyenas. They're the ones who are already in a position to fight. They're not doing this for the first time in 25 years. And those are the lawyers that get the better settlements, because an insurance company, when they have two lawyers, the one brand new case, right? Brand new case. We see this all the time. You have the attorneys right over here who have settled 99.9% of their cases and took
Right.
less than one, to litigation. And then these guys over here, they've litigated 10% of every case we've ever had with them. Who's going to get the better offer? Obviously, the ones who litigate, because the ones who litigate know their stuff, and they're not afraid to fight if they're not going to get a fair offer.
Right.
You have a better standing with a lawyer that litigates both in criminal and
Do
civil.
you get that? That's actually interesting to me. I certainly get it in PI, but at the smaller end. When it gets complicated, they get freak out and they refer it to me. But at the smaller end, like, do you have like just guys who have no idea, thinking, "Oh yeah, I can just like do DUI defense," but they really have no clue. I mean, I'm not asking you to
Sure.
name people, but like,
No, no, no.
like you know what I mean? Like attorneys who really have no business going, "Oh yeah, I'll take some DUI defense."
Yeah, give me $250 and I'll talk to the prosecutor for you. It's yeah. They're everywhere, man. It's not just Kentucky. And that's okay. That's their gig, and some people are okay with it. They just want, hold my hand as we're going down. It's like to say, hold my hand as we're going down the guilty plea aisle,
Uh-huh.
And some people want that, but don't expect you're gonna get like top-notch representation for 250, $500.
And a plea is a good result in a lot of cases, but
Yeah.
the question is, what sort of leverage do you have to get the best deal under your circumstance? That I mean, I see this in these courtrooms because I've been doing this, where like a lot of times if it's first time, and I'm sure it's the same throughout the country, like if you're a first time DUI, they'll like amend it down to some sort of reckless driving or some weird charge that's not DUI, or they'll give you
Like
what's
a
called a
wet reckless.
supervision, and that's a really good deal. And maybe just like an amateur could pull that off because there's no priors, and a really good attorney would get basically the same result, or maybe not. It depends on the factors. But if you have like priors or an aggravating circumstance or a high BAC and they usually have one of those things, by the way. I
There's
mean, it's
always
rare you
something.
get like the school mom who just had one too many, and she's a .09 coming home from the PTA meeting and with nothing else involved. It happens, but it's rare. You usually are doing something else stupid. I'm just saying.
You're right. You're absolutely
Stupid
right.
usually multiplies when you're doing things,
Tracy asks, what kind of questions did I ask jurors after I won that the 4-minute verdict, the not guilty verdict? I don't remember, honestly. I would tell you I don't remember. And it's not about, sometimes it's not about the questions, it's about of the jurors, asking the questions of the jurors, that is, not the police officer. It's about the evidence. I mean, you got to have the right facts. Again, a
How'd you
good
bang them
trial
out in
lawyer.
4 minutes? How did they even get a 4-person in 4 minutes?
I have two 3-word verdicts. Do you know what a 3-word verdict is, Mike?
Mm-mm.
Not fucking guilty. I have two. I'm a proud owner of two, and that's 5 minutes or less. Or like, I don't know. Some people say 10 minutes or less, whatever. 5 minutes or less. I have two. I have one 4-minute verdict and one 5-minute verdict. Those, yeah. I mean, you got to have the right case. A good trial lawyer knows which cases to take to trial. Do you think I try every single case? I mean, that would be ludicrous. That
Yeah.
would be stupid, because I would be losing all these cases that I have no business winning in the first place. Why would I litigate them?
Right.
We cherry pick, and if the client, you got to have so many elements that have to be in place. You got to have good facts. You got to have either good or no video. You got to have a good witness, and your client in criminal cases must be able to afford it. In the civil arena, it's a little bit different, but also similar. If you have a potential policy limits case, where the policy limits are 25,000, let's say, and the offer on the table is already, I don't know, let's call it 14 or 15, taking it to trial, you're only maybe gaining potentially that, you're gambling on that additional 10, 11,000 may not be worth. But if it's $1 million policy and the last offer is 50 grand, and you think this is a $500,000 case, I mean, now you're talking a potential increase of 450,000 or more. That is absolutely worth the time and effort to go to litigation on and see if you can get more money. I mean, and it all depends on the case too. Maybe that $11,000 difference case is worth on principle alone just to stick it to the insurance company.
Yep. Sometimes I just try them because, well, my client's not happy and and I'm like, whatever, I'll just let the judge or jury tell them. That's it.
And by the way,
I don't get judges because I have insurance companies and they'll file a jury demand every time because it's better for them.
Right. And I always forget, can the jury award more than the policy limits against an insurance company? Yeah.
And what you want to do is you want to set up whatever. I don't want to get too law nerdy here. You want to set up an excess verdict. You want to say, we would settle within the policy limits if you pay it the next 30 days. And if you don't, we're going to hold you responsible for the excess.
There it is.
That's called perfecting an excess claim, and that's when it's fun because that's when they're scared. I'm gonna be evil now, but that's when you're like, do you guys feel lucky? Really? You want to do this thing?
I'm starting to get into plaintiff litigation, so that's where I'm going from.
You sound like you have a very good familiarity.
Going from beyond. I have to basically, what is it? The DUI exception to the Constitution, where I have to prove my case beyond a reasonable doubt as the defense attorney. Sometimes is what it feels like. Now I get to be a prosecutor, and the burden of proof is preponderance of the evidence. Are you kidding me? I want to do that. And there's money on the line. I don't know. I'm getting excited as we're getting more and more of these cases.
Oh, that's fun. Again, and that's the same thing. So you're doing DO stuff, but all that will translate. You'll be like, oh, okay, well, now I have to do the discovery this way, or I have to do this other stuff. But your trial skills will just translate right over. You're still trying to relate to people and explain, the little provisions are nothing to us as attorneys who went through law school. We've learned a bunch of different things. That's
the real learning happens in practice. Would you agree? Yep. What state do you practice in, Mike? Stone Glasgow is asking.
Illinois.
He's up north.
I'm right there. We got Chicago in the background. It's freezing. It's still horrible up here.
Some of these I'm just skipping because I can't. It's going to be like a half an hour discussion explaining, or I just don't have an answer.
I get that in my comments, which is understandable. And from clients, the classic, again, that's what made me think of when you were making me laugh, and they're just like, how do I handle this? The classic case you get as a personal injury attorney, you'll get this. How much is my case worth? Okay, well, that's basically the entirety of my job. That can take years to figure out. I mean, where do I start? What are your injuries? What are your bills? How did it happen? What's the liability? I mean, it's a 17-hour question minimum,
If you don't have the money to take the DUI classes, can they put you in jail? Yeah. Actually, they can. If you don't take them for a lengthy period of time and you get in front of a judge, and each time the judge asks, have you completed your classes on your show cause date, and you don't have a good answer, eventually the judge may get upset with you and throw you in jail. So do your classes. If you don't have the money, find it. They're not that expensive. They're not, especially on a first offense DUI. I think it's like $200 start to finish, all your classes. If you can't afford $200,
I mean, isn't there somebody you could contact and literally say, this is my problem, I want to do it?
There is a program in Kentucky, and I think most other states, for the indigent. If you're indigent and you can do they're obligated to accept, I think, 20% for free. 20% of the people that they take in maximum have to be like indigent people. So, and they get paid by the state anyway. So they get paid either way. It's that you don't have to pay. The state pays for you, taxpayers. Is there a situation when you should talk to the police if you're not the victim? No. Never talk to the police. That's an easy one. Rod, you asked this question a couple of times. What is your form or style of notes for examination in chief and cross? What does that mean? I write the questions down and then I ask them in court. That's it. What's my style?
I mean, do you write down? Cross-examination. I mean, you can anticipate what testimony is going to be, so you have some idea of what you think you might cross somebody on ahead of time. But honestly, it depends on what they're saying on direct. So if you're crossing somebody, you're sitting there listening to the testimony and formulating your cross as it occurs. Basically. I mean, if you prep for trial, you have some notion of what that testimony is and how you're going to respond to it. But it does change because they will surprise you in court.
What's your reset button after a tough day in court?
A nap?
Nap? For me, either nap or I know this is going to sound so freaking nerdy. I play chess. So for me, I decompress, and this is going to sound even weirder. I decompress with a 1-minute bullet game of chess. And not just one, I play 20 in a row, which only takes 35 minutes really, depending. But yeah,
no, that makes sense to me.
It just
I'll tell you why.
I do something completely different,
It also occupies your mind. It's more restful. If you sit there, if you just had a pile of stress, and let's say you just lay down and close your eyes, you're just going to relive all that stress. You want something to divert it. So it actually makes sense. But having said that, you are a law nerd.
I'll take it. Jenny, I already answered that question. Leave us alone. We support auditors. We're not against them, right,
yeah.
Mike? We're not I don't understand why she keeps asking that question. Hey, Mike Jones, what's up, brother? You're late to the party. Really, really late to the party. Here's a decent one. Do you think media public outcry ever plays a factor in decisions? If so, is a decision partially made at the start of the trial? Sometimes the media obviously affects cases, no question about it. But for the most part, obviously, you want to have as little media impact on a case as possible, unless it's in your favor. That's the bottom line.
Mm-hmm.
Have you ever witnessed an excellent pro se case? Not yet. I've seen some crappy ones, but never a really, really good one.
I haven't. The best I've seen, and this is not particularly interesting, but I've seen a ton of them in front of me, and every attorney rolling their eyes and dying because they're destroying themselves and they're slowing things down. But the one place I've seen pro ses do well is some property managers who are doing evictions, and it's kind of simple, and they did it a lot, and they're not attorneys, but they got good at it. But it's a very, very limited, narrow scope, and they learned that law, and they weren't attorneys, but they were very sophisticated at it. So it's possible, but it's not common.
Dude, Lackluster is almost at 400,000.
I would say that's
amazing.
Anything but lackluster.
Apparently that was his gamer tag or something, because I asked him about it. I was like, why did you call yourself Lackluster? And he's like, I don't know. That was always my tag. So when I created the channel, he had a gaming channel at one point, apparently. It was also called Lackluster Gaming or something. And then he started doing the cop videos, and he just became the best at it, man. He's one of the best out there. I love his channel.
I'll have to check it out.
Are you not familiar with Lackluster?
No.
Oh man, you're in for a treat. He puts out a lot of excellent content. I think I lost my place. There's just so many comments. I can't keep up. I'm sorry, you guys.
That's a good problem to have, my man.
It's because you're here. They were quiet as little ducks in the beginning, and then you show up, and the chat just explodes, man. This is all you. Jeffrey Murray asks, Nebraska's recent DUI laws, what do you think of them? More overreach for cops and dude, I don't know. I don't know anything about Nebraska. I don't know why you're asking a Kentucky lawyer about that. I'm happy to look into it for you for money.
Right. Right. You just send the retainer right over to my office. I'll get on it.
I'll get on it right away. I want to enroll in law school. Oh, this is a good one. Oh, I love these questions, man. I want to enroll in law school in 2 years doing intellectual property. By the way, you think you're going to be doing intellectual property, you're going to change your mind 15 times while you're in law school. Just remember that. But if you come out intellectual property, more power to you. Any advice, tips on studying for the LSAT? Okay, this is my 60-second rundown for LSAT folks. LSAT is just like the bar exam in the sense of it's a marathon. It's not a sprint. So you're not going to study like cram the night before the test, and then you're going to pass with flying colors, get the best score in the universe. You want to understand the schematic of the test, right? How do you do that? Get a bunch of practice tests, run them through. First, no time limit. Then when you finally get a feel for them, because you're going to see it's a cookie cutter pattern. You know, there's section 1, 2, 3, 4, 5, whatever. If there's essay these days, I don't even know if they do or not. And then you may even skip the essay. You know, the essay is only testing on certain factors. You can research on it. But the multiple choice are all going to be the same. It's the same schematic of the story. On the reading portion, it's the same logic games. Are going to keep repeating with different names and different factors and different whatever. Just learn how to do them, how to crunch them fast. That's all it is. And it's
all like logic. It's not specific stuff. I mean,
yeah, it's not going to teach you. It's not going to ask you like, you know, what is the law on what's bird law in Nebraska? Right. What is the current statute Nebraska law 137 on birds? No, it's going to ask you very, very generic. It's preparing you to be able to decipher those blank and blank, blank or blank. Blank is, if then blank, or if blank then blank. Like all of these cookie cutter patterns that you're going to see when you go to law school, and you're going to see it in statutes. They want to make sure that your brain has the capacity to recognize the difference between them. And the better you can recognize them and the faster you can recognize them, the better off you're going to be. So don't study like those books. Just do practice tests. And then crunch your time.
That's what I was going to say. I mean, it was ages ago. I think it was Stanley Kaplan or whatever it was at the time when I took it. I literally went and bought it, and it was a bunch of practice tests. It was like it was actual physical paper. This is an internet time. And I would just take out a pen and I just did them for a few hours, like for a little while. And then I'm like, okay, I'm pretty comfortable with it. And that was that.
Yeah.
I mean, if you're ready or not, because you'll take it. And if you're not getting better, you're not ready.
Yeah. So you want to make sure, like, give yourself enough time. And they offer it like 4 times a year. So you should be fine, Zybe Zane. Study. You got 2 years. I mean, I wouldn't even pick it up yet. That's too much. That's too much pressure, man.
I wanted to pro se, and now I'm not sure. Mike Mendoza, what are you talking about? I'm not a fan of you guys anymore.
Not a fan of it. No.
Were you ever a fan? Come on, say it isn't so, Mike.
Say it isn't so.
What can we do to get you back?
Yeah, for real. I wanted to pro se, and now I'm not sure. Tell us more, Mike. What's going on here? What the hell? We both just lost a subscriber. -1, Mike.
I hate it when I get these questions. You can relate. Like when I get something like this, I'm torn because I have a bunch of like funny people in my comments will troll me with stuff like this. So like I don't know. Like, is it you? I don't know. They like to just taunt me. They'll pose as sovereign citizens, for instance. So I'll get that. What about the jurisdiction? And then like, all right, is this one of my people, or is this somebody who really believes this nonsense?
I have a video in the hopper that talks about that a little bit. So I can't say much, but we'll see. When it comes out, you'll know. Is there a place to practice being in an outside setting of college? You scared the shit out of me. What does that mean?
I think they've actually got this mixed up with like a text conversation they're having with somebody else.
I think so. Yeah, you're in the wrong chat, bro. How How to get away with cheating on your taxes. What the hell, man? That's a troll right there. We
Yeah.
don't get out of here. Trial type setting. Okay, so all right, Mike. If you want Mike Mendoza is what I'm talking to. Mike Mendoza, if you want uh to do like if I understand you correctly, if you want to try the case in front of a what do you call those panels? Oh my goodness, it's escaping me right now. A lot of like big like tobacco litigation used to love to do this because they had millions of dollars that they could throw. Focus groups.
Focus groups. Oh yeah.
If you want to do a focus group trial to see what like members of the public would think of your case before you actually bring it to trial in an actual courtroom, that's a very smart decision.
And very
So
expensive.
it's extremely expensive because you have to grab people off the street, pay them for the time. You got to get a bunch of lawyers in the room. One's going to be a prosecutor, the other one's going to be the defense attorney. You're going to pay for their time, and you're basically trying the case before you try it. So hopefully you don't have like a minor misdemeanor because you don't want to be spending $20,000 on a focus group, and then and the penalty on the if you lose is like 10 days in jail or something like that. You may be smarter to just roll the dice or take a plea deal. I don't know what your case is, but
Mike, don't do it.
Yeah, focus groups are reserved to like these $1 million cases. So if that's what you're asking, then don't do it. Mike's right. What is public records considered for an area of practice, civil, constitutional, etc.? Public records are available for anybody who wants to look at them, Cleveland.
I don't know the contours of what public records are. I don't know. I just don't understand the question. It's not specific enough. I'm sure they have it straight in their head, but I can't ferret it out from that.
Well, listen, Mike, I've been going at this for 2 hours now. I'm exhausted. I need sleep.
Thanks for having me on,
dude. Thanks for joining. This is like totally unexpected. We went from one person to two people. Look at that.
That was a lot of fun. We are going to do that. That's what it was too. It came up. It's a show cause hearing.
Okay,
but
okay,
it's like it's deep and dirty DUI stuff. It's in Washington State, but you'll know what's going on. It'll rip your soul out. It will.
I can't wait. I love soul ripping content.
Thank you so much. I appreciate it.
Thanks for joining me, Mike. Say bye to Mike, everybody. Thanks for joining us, man. It's been a pleasure, and we'll do some more live soon. All right. All right, you guys. I'm going to sign off here. I'm exhausted. Thank you so much for joining. I had so much fun with Mike. This was completely unexpected. I did not expect for him to show up in the chat and be like, what's up? And then join me live. Some of these things as content creators, we always get a little bit of a knack for. So this was awesome. This was absolutely awesome. Again, thank you, Mike, for joining me and answering questions with me for you guys. So for your entertainment, for your knowledge, and for the most part, I hope you all enjoyed the content. I mean, obviously, how to win a jury trial. This is not a comprehensive guide on how to win a jury trial, and it's also not a cursory review. We went pretty in depth on jury trials and what to do and how to do them. So those of you who are looking to try your own case, Godspeed to you. I mean, those are extremely hard. I wish you nothing but the best. Obviously, study the law, understand the law, study procedure, understand procedure when you go into that courtroom. Look professional, act professional, and hopefully you can win your case. But if it's anything more than like a speeding ticket, absolutely, under any circumstances, do not try your own case. Hire a professional. This is what would you try to fix your own car if you have no idea how cars work and just start picking it apart in the hopes that you can put it back together? Some people can do it. Less than 1% of the populace, I would say. The other 99.9% should not do it. So hire a lawyer, hire a professional, hire someone like myself who can help you run through the ringer. If you can afford it, by all means. If you can't afford it, maybe you can get the public defender. So you want somebody on your side. You do not want to go at it alone. Can citizens attend jury trials? Absolutely. They're open to the public. So you're more than welcome to go see what they look like before you try your own cases. So thank you everybody for joining me. Sync to me. Thank you for that, brother. I appreciate that. Sync to me. Thomas McNulty, Rob, Den, Mike, Tabby, Law Talk with Mike, of course. Excuse me, Rob, aka Mom, aka Wife, Paula, Jeffrey, Jenny, Carol, who am I missing? Fred, Alexander, Cleveland Body Camera, Thomas McNulty, Rockchild, Den, Stone, Lab, Tracy. Who am I missing? Liberty Cause was in here. Mr. Tex, what's up, man? Sorry, I didn't get to your question. We're just signing off here. I saw Red Rex there earlier. Dreamland. Thank you, everybody. Zybe Zane, thank you for your donos. Thank you for joining me. Thank you for being here. Thank you for being you. Thank you for being a fan. I mean, this has been absolutely amazing, you guys. I had so much fun. So next time we're going to be doing this either next week or the week after. I'm going to try and get Chris back on. Maybe we'll do another one of these educational ones in the meantime. I don't know. Big news. We're moving into our new office in less than 3 weeks. So hopefully this background is finally going to change permanently while we're in that building and no longer going to be working from home as everybody's coming back to work. Good night, everybody. Take care of yourselves. Take care of each other. Take care of your mental and physical health. And I will see you all in the next video. So peace out. Love you all.